Want to welcome you to the annual client update. It's been 2 years since we've been able to do this live. Yeah, I mean that's we're really pretty excited about it. When I asked my fellow attorneys, should we go live or do another Zoom, it was an overwhelming, let's go live. So we're actually doing both today. We want to welcome also our people joining the program on Zoom. This program is being live streamed. So they're hearing everything that you're hearing, seeing everything that you're seeing. I missed all of you. And as I've aged, I recognize faces and not always the names. So please forgive me if I have to say, who are you? But it's nice to have you all back. If you haven't gotten your food, the food is outside. You're free to roam out there anytime you like. This program will be also available after this program. We're recording it, and it's going to be on our YouTube channel, which is incredibly easy to find. You just type the words Angermeier and Rogers YouTube, and poof, you'll show up. There are about already 20 programs on there, including the last 2 that we've done by Zoom. So you're welcome to do that. We'll take questions at the end, again, because we're recording it. It's just going to be easier and smoother if we do that. So what you're seeing is that this slide it's the worst visually of the whole group. All the rest are pretty visible. But what it says up there is that I'm going to do an office update. Then there's going to be a tax law update that Vince Angermeier and I worked on. Stacy Vogeltans is going to do a program on a long-term care issue. What happens when we start seeing our capacity diminish a little bit, ourselves or our spouse. We're going to talk about pet trusts. That's going to be Brenda Schleiss. Then Roman and I, who are tackling the trust administrations in the office, are going to do the successor trustee refresher course that we do every year, and then we'll wrap it up with questions. I will no doubt at one point or another hit the wrong button on my remote control and shut the whole program down. So be patient in case I do that. So we'll move on to the next slide and what's going on in the office. Pretty much everybody has stayed the same. Katie Soderlund is still helping develop the plans and doing the funding for that. Patty Tesmer is our fabulous receptionist. She's in the back. Wave at us, Patty. Thank you. Client services, the person that is most responsible for everything that's going to go wrong today is Annette Geiger. She's in the back. She's waving to you. She's worked on this program for years. And then we have a new trust administration paralegal. Sadly, what happens when you have an estate planning practice is you do a lot of planning at the beginning of your career, and then people start passing away. And so Tammy Rundle, who's been with us forever, is one of the 2 paralegals. And then we hired about a year ago, Camise Figures. We were lucky enough to catch her on the way up here from Atlanta. She was going to relocate anyway, and we got her resume and had a chance to hire somebody wonderful. The other change is Claire. Some of you had worked with Claire Geiger, now known as Claire Guest. And she was working in a job I think she wasn't too thrilled with, asked me if I could find a place for her, and wow, was that an easy question. She's so outstanding, so I've kind of having her helping me with office management, which has been a godsend. So that's the scoop on what's going on at the office. And then what about the attorneys? The big change here, the trust and estate planning is still done by everybody in the room. And that's Roman, Amanda, Stacy, Brenda, Vince, and me. And then the trust administration, Roman and I have sort of moved into doing that. And Amanda has been helping us with the tax work. Vince helps with new probate cases. And then there's me all over the place. And then elder law and Medicaid planning, that's primarily Stacy. I feel like a fraud putting my name down there on the list. I think Stacy asks me a question once a month. And then that's in exchange for the 8 or 9 questions I ask her. So she does a great job on that. So that's the office update. Now we're going to move on to the tax law update that Vince and I worked on. And you can see our pictures up there. That's me with a tie. You're not going to see that very often. So let's see what we're going to talk about today, because there have been some things, particularly new development. So we talked the last couple of years about the Secure Act. This is the law that governs how IRAs work, when you have to take your required minimum distribution, when you send that IRA, the leftovers, to your kids, how long do they have to pull it out? And so there's been a recent change, and we want to notify you about that today. We're going to talk about where we stand currently with estate taxes and where they're headed. We're starting to get closer and closer to the sunset date. So the current estate tax law was passed in 2018, and then it had a sunset of 2026, and here we are at 2022. So we're going to talk about that. And then because of that sunset, there's some planning opportunities that we can get at, and we want to talk about those. So let's start with the Secure Act. This just got clarification in 2022. Now, this law went into effect for deaths starting January 1, 2020. And if you were in the wrong spot as I was, I have had to start taking my RMDs at 70 and a half. But some of you who have just had birthdays can start taking your required minimum distributions at age 72. But the new change in the law affects beneficiaries of inherited IRAs. And so the pundits have told us initially, when this act was passed, that most of the kids that are receiving an inherited IRA will have a 10-year time period after their parent dies to withdraw the money. We thought it could be any time in that 10-year period, including the last day of the 10th year. I could wait all the way to the end. There are no required minimum distributions. It turns out the IRS didn't think that. And so they issued a guidance. Did that advance at all? No? There we go. So it's in red. What they said was, if you're a parent, had already started taking the required minimum distributions, which means they were at 70 and a half a few years ago, or 72 now, if they're pulling money out, then and you inherit that IRA, you also must start taking required minimum distributions the year after the death for the next 10 years. And it's you use there's a table for life expectancy. So if I'm 41 when I inherit, I'll have a longer period of time to pull the money out in terms of the dollars that come out. Lower amounts will be in the required minimum distributions than if I were older. But we pretend as though we're going to follow that life expectancy table all the way to the end of your life. But what happens is, in years 1 through 9, we use the table, and in year 10, you have to pull the rest of the money out. And since we advised our clients that you didn't have to take the money out when people died, we told the kids, you don't have to pull money out, you can wait as long as you like up to the 10th year. We're going to have to tell all those people that's not so. The IRS did one nice thing. What they told us is, we know people may not have taken the required minimum distribution in 2021 or 2022, and we're not going to impose the penalty for failing to withdraw. You still have to take them. So if you inherited an IRA, but you'll have time to recover from that problem. Let's move on to the estate tax. So again, in 2018, the exemption was set at $10 million. In English, the exemption means if you don't have up to $10 million in your estate, you don't even have to file an estate tax return, much less pay the tax. So the exemption is indexed for inflation, and it started off initially. And right now, in 2022, the exemption has grown to $12,060,000. And the IRS has paid attention to the idea that there is inflation. And so they have, since this was indexed for inflation in 2023, the exemption has jumped to $12,920,000, nearly $13,000 or $13 million per person. So if you're married, you double that, right? You get $24,000 almost, or $25,000, 26 it is, $26,000 next year. So, and married couples can transfer unused exemption to each other. So husband dies and then leaves everything to his spouse, which means there's no estate tax because of the unlimited marital deduction. So basically the husband did not use his exemption. He gets to transfer that unused exemption to his spouse, who now can walk around with a $26 million exemption for when she passes away. So that's going to be a permanent feature of the tax law. But what's going to happen is in January 1, 2026, this exemption will roll back to half its amount. So it's $5 million indexed for inflation. Our estimates are that it will be at $7 million per person. So if you're a couple, that should be about $14 million. So what we're looking for is people who are starting to hit that $7 million or more in a taxable estate, and even more urgent if the combined estate is over $14 million. So let's take a look at some of the things that Congress has done. The tax rate for estates has been stable. It's 40%. If you get over the exemption amount, 40% of the money goes to the government. The other 60% can go to your kids. And then in 2021, we actually want to look backwards and see what Congress has proposed but then rejected. And so when we were trying to fund this infrastructure bill, there were all kinds of proposals floating through Congress. One of them was including what's called a grantor trust in the taxable estate of the individual. Now let me tell you what a grantor trust is, and you won't remember it, but I think you'll understand it pretty well right now. And that is, a grantor trust is not yours, or it is yours for income tax purposes. So if the assets in the grantor trust throw off interest, dividends, capital gains, that goes on your tax return as the person that created it. But people do this so that they can get things out of their taxable estate. So it's you own it for income tax purposes, but you don't own it for gift and estate tax purposes. It's out of your estate. And so Congress is talking about starting to include those grantor trusts in the taxable estate of the individual. But they were willing to say that if you had a grantor trust before the effective date of our statute, then that's grandfathered in. So we're going to be looking to see if these concepts resurface. Congress also looked at getting rid of the step up in basis. A step up in basis, I think we talk about this at almost every program. It's so hard, it's easy to say, but hard to understand. When you own something that you bought for $100,000 and it's grown in value to $200,000, the basis in that asset is the $100,000 you paid. And so the step up in basis is something that happens when you die. We upgrade the basis to date of death value. So it has the effect of, think of it this way, it just erases built up capital gain for your beneficiaries. So that, again, Congress is looking at limiting that, and we'll see if that happens or not. Let's take a look and see where we are on the gift tax. In 2022, if you make a transfer while you're alive, and that's the only difference between the gift tax and the estate tax. If the transfer occurs while you're living, it's the gift tax. If the transfer occurs after you've died, it's the estate tax. It's the same tax. And so there's a special exemption for lifetime transfers. It's called the annual exclusion. People remember it as being at $10,000, but it's been indexed for inflation all these years, and it's grown to $16,000 per person per year. So if you're married, you can transfer $32,000 to a son or daughter, and if you want to include their spouse, now it's $64,000 that you can transfer. Husband transfers half of the money, wife transfers the other half, and then it's split between your son and daughter-in-law. And then in 2023, finally this exemption is going to go up to $17,000 per year. And people always wonder what happens when I make a gift bigger than the exemption, the annual exclusion amount. Nothing. You just have to file a gift tax return and report it. But until you hit the exemption amount of $12,060,000, there's no tax to pay. So it's just a reporting requirement. So first you get away with no reporting if you use the annual exclusion. Then you got to report from 16,000 all the way up to 12,060,000. And then when you go over 12,060,000 during your life, get out your checkbook. So the gift tax is not terribly worrisome. But now that you know these things, there's a technique that we look at for individuals who are married. And we're going to talk about, this is just one of the many things you can do. It's called a SLAT, not a charming name, S-L-A-T. And we're going to see what a SLAT is, how does it work, and what are the pluses and minuses. So what is a SLAT? Well, the letters stand for Spousal Lifetime Access Trust. And what the technique is let's say we've got a couple with a $15 million combined estate. So each of them have about $7.5 million. And the issue is, right now, each of them have a bigger exemption, a $12 million exemption. Should they use it if they can? Because it's going to drop in 2026 to $7 million. So it's a use it or lose it idea on the big money. So we look at transferring, if we can, over $6 or $7 million out of one person's estate. That's what the SLAT does. But the nice thing about that type of trust is it allows your spouse to access, use, and enjoy the money. So I haven't really gotten it out of my estate for purposes of being able to use it, but it is out of my taxable estate in a trust for the benefit of my spouse. So let's talk about how this thing works. So first of all, we have to figure out who's going to make the gift, husband or wife. And often it's both of us who will make a transfer. We have to pick a trustee. Can it be your spouse? So I'm making a spouse or a trust for the benefit of my spouse. Can she or he also control it as trustee? Not a great idea. It's a bit dangerous. Things can go wrong a little bit easier, but you still can do it. But it's better if you have an adult child with their brain connected, and let them serve as trustee, and they'll make sure if money needs to get over for the use of the couple, that I'm the person that gets the distribution, or I decide what the distributions are for the spouse. And things just work great. So the beneficiary typically is going to be the spouse in some fashion or another during that spouse's lifetime. So each of the spouses can create one of these for the other if you want, but of course the IRS thinks that that's a dangerous thing to do. So they have a doctrine that they don't want you to violate called the reciprocal trust doctrine. Don't make a deal with your spouse. I'll set one up for you, you set one up for me, and then we'll not lose any access or control. And it turns out you can still do it, but you just have to make the trusts different enough from each other that the IRS will say that you didn't violate this reciprocal trust rule. They have not set out nice, clear guidelines for us to work with. So we have to do all kinds of things to make sure that that doctrine isn't applied against us. So for example, the way you name the trust, you want to kind of have it match up with what we're trying to do. So one of the names that we often use is the spousal support trust. So if it's a Smith family, the husband is setting up this trust for the benefit of his wife. It's going to really include pretty much every bit of access that we want that spouse to have to support his or her lifestyle. So that's the support trust. And then if we want to do a slightly different trust for her trust for the benefit of him, it might be a family legacy trust, where he's one of the beneficiaries, but not the only beneficiary during his lifetime. It can be for the kids, it could be for my parents. But the one thing that we do in both trusts is we'll usually make the trust going to the kids after the spouse dies identical to the trust that we see in your revocable living trust so that we can merge them all together. So it's a trust really meant to make sure that our spouse has continuing access to the money that I have now technically transferred out of my taxable estate. So the different functions will change the access to the spouse. The things that we tinker with are on the board. Income, do you get all the income, or do you just get income in discretion of the trustee? Do you get principal? Often that is the right thing to do for HEMS, which is health, education, maintenance, and support. Practically everything you can think of. You might have different provisions for whether if my spouse remarried after I died, would I require him or her to get a prenuptial agreement or not? Do I want to allow them to appoint property, that is to direct property to others in the family? Yes, I can do that during lifetime and at death. So we tinker with all these things, and husband's trust for wife and wife's trust for husband will vary on these subjects. But the idea is we don't want to close off the access to the spouse. So one of the things that we can do to avoid this reciprocal trust doctrine is certainly set the trusts up on different days. Different months would be even better. Different years, all the better. And right now, we're obviously, when we set these up, we're doing them in December, and then we can move into January or February, and that'll help make things look different. And of course, using different trustees makes sense. But as I said, we want to make sure the provisions for the kids after the spouses are out of the picture are identical. So that's called a slat. What are the advantages and disadvantages? I love this slide. Tammy in our office does the slides, but the upside is the up arrow, the downside is the down arrow. So the upside is it reduces the taxable estate of the donor spouse, whichever spouse sets up the trust. And if we can transfer more than our half of the big exemption, 7 million, 8 million, 9 million, if we can stand to do that, then we're using exemption that's going to go away and leave us in 2026. But some people with smaller, and by smaller, I'm thinking $6 to $12 million estates, they're not so worried about the estate tax, but maybe they're worried about asset protection. What if there's a lawsuit or claim? What if we have my favorite accident that Roman describes when we do client seminars, and that is you run a red light on Blue Mound Road and you hit a van full of trial lawyers. So that is not the best moment for your estate in terms of creditor claims. And so that kind of protection is in place. But people, the examples of where asset protection can benefit you are numerous. If you've got rental properties, it's going to help you with that. Just driving a car is one of the issues that can happen. You might own a business, and so protection from lawsuits and claims that come out of that would be useful. And again, the other upside is that's in spite of the protection from estate taxes and also lawsuits and claims, your spouse has the use and enjoyment of the money. The downside, it's us. So you got to pay us to set this kind of thing up and fund the trust and move things in. And if you're trying to get things out of your taxable estate, the trust that we set up will not get a step-up in basis when you die. If you're going to set it up just for asset protection, then we're able to put provisions in where you will get a step-up in basis. And then if you're trying to avoid estate tax by getting things out of your taxable estate, you do have to file a gift tax return. Remember, if you go over the annual exclusion amount of $16,000 per year, you just have to start filing a tax return until you hit $12 million. So this is one of the cases where you'd end up doing that. So again, remember, if you are interested in this, you can always call us and talk to us about it. And we'll be happy to sit down and explain the things that you didn't understand from this presentation. So now we're ready to move on to a new subject. Stacy Vogeltans is going to talk about a long-term care issue.
All right. Good afternoon, everyone. What I'm going to talk about is kind of walk you through the process of what might need to happen from the beginning of getting a diagnosis or realizing you have diminished capacity through actually moving into a long-term care facility. Okay, so when might you contact us when we're talking about this issue? So maybe you just came back from the doctor and your husband got a diagnosis of dementia or early onset Alzheimer's. So you just got this diagnosis. You haven't really noticed problems, but you're worried. You want to know what should be done at this point before it gets too late, before the incapacity gets too bad. Maybe there's not a formal diagnosis, but your family members have noticed that, maybe you've got adult children and you notice mom is having some trouble. She's having trouble just getting around her house, getting up and down the stairs. She's having trouble remembering to pay the bills on time. And so you're concerned that, you're going to get her to the doctor, but right now you're just concerned about her handling the finances on her own. Or maybe you realize yourself that you could use a little bit of help. Maybe, you've laughed it off as senior moments, but those senior moments are coming more and more frequently. And you think that, it might be a good idea at this point to get some help managing your finances. So we're talking right now just kind of at those beginning stages. No one is fully incapacitated, but we realize that there could be an issue down the road, whether it's, 6 months from now or 3 years from now. We don't know how it's going to progress, but we want to make sure we're prepared. So what could our office help with at this point? Why do we want you to call our office, set up an appointment, get in to talk about things? The main reason is going to be that we want to make sure that your agents, trustees, personal representatives are the right people for you. So what we might end up doing is appointing a co-trustee to serve with you. What we might end up doing is removing the person who has the diminished capacity. What we might do is have that person resign as trustee. So just a couple examples of how this might work. So, mom is her own trustee at this point. Maybe dad died a few years ago and mom is managing the trust herself, but it would be nice at this point if we could take her adult son and bump him up as a co-trustee so that mom doesn't have to do it alone. There's someone there to help her. So that's one way it might work. Maybe we've got a husband and wife, and husband has that dementia diagnosis, and he realizes it, and he doesn't want to cause any problems. So he's willing to resign as trustee of his own trust, and wife is just going to serve alone as the trustee because she's still sharp as a tack. So that's another way we might do it. And unfortunately, maybe we've got a situation where somebody has diminished capacity, but they don't realize it. So maybe we've got, husband and wife, and husband is, going online and ordering things, and he doesn't remember doing it. He doesn't remember where he's given that credit card number out to, but he doesn't think there's a problem. Unfortunately, in that situation, what we might have to do is get a doctor to determine that he's incapacitated at this point, and he should not have access to that credit card. He should not be serving under the trust or as power of attorney. So those are just different options, different ways that we might have to go about updating your documents when we get that diminished capacity setting in. Other than updating your agents and your trustees, we also want to make sure that all of your estate planning documents are up to date and they say what you want them to. So if you've been toying around with the idea of, maybe adding the grandchildren in as beneficiaries under your trust, you want to make sure that college is paid for them, or you wanted to leave a gift to your church, you want to make a donation after you pass away, now would be the time to actually update your trust or update your will and get those terms in there. Because if you get to the point where you are fully incapacitated, you can't change your documents, you can't amend your documents. So at this point, you would really want to make sure that your documents are the way you want them to be. Another thing that we would do on our end is we would make sure that your documents are up to date and not out of date. So that might be some of tax planning, some of what Mark talked about. It might just be that you had your documents set up 10, 15, 20 years ago, and we're doing things a little bit differently right now. The tax laws are a little bit different right now, and so you'd benefit from getting the documents updated. It could also be that the power of attorneys are just a little bit older, and we want to see those updated. So that the documents don't go bad, they don't actually get out of date from a legal standpoint. But what we see more and more often in our office is that the banks think that they go bad. So even though your power of attorney document is fully valid, the bank might call us up or tell you to have an attorney sign off on it saying that it's still valid. And so sometimes we've just been updating those power of attorney documents as a matter of practice if they are 10, 15 years old, just to avoid that down the road when we're also dealing with diminished capacity or other issues. Let's just get those updated while we've got you in the office. And then we also want to make sure that your documents have all of the tools in them that we need if down the road we're going to be worried about having to pay for long-term care in a facility, and we want to eventually get you qualified for Medicaid. We want to make sure all the right terms are in your documents to make sure that we can do that for you. So that's kind of the first step when we realize something might be going wrong. And then the next step would be, what if we're actually ready to start looking for help? So maybe now we are a year or two down the road after that diagnosis, and we've got to learn a little bit about this process and what options are out there. So I will start by telling you it's kind of a cumbersome, hard process to navigate. There's a lot that goes into it. There's a lot that you don't know until you start looking into it. So when it comes to looking for a long-term care facility, you're going to see there are a lot of different types. There are assisted living facilities, there are CBRFs, there are memory care units, there are skilled nursing facilities, there's care at home. So there's a lot of different long-term care facilities. It's not just a nursing home like it used to be 20 years ago. So there are a lot of different options out there. So just learning what those options are can be kind of overwhelming. And then learning how to pay for those options. So those options might range somewhere from, $5,000 to $6,000 for an assisted living up to over $12,000 for a skilled nursing home. So when you start looking into this and you realize how much it's going to cost, that's when we get the question of, how do we pay for this? How do we protect assets? And that's where the Medicaid conversation comes up. So this is another place where you see a lot of different terms. Medicaid and Medicare are different terms, and only Medicaid is the program that will pay for your long-term care. And then even further, to complicate things even more, they call Medicaid by a bunch of different names. So it might be called Medicaid, it might be called Title 19, it might be called family care, it might be called community waivers. So you might be going to a facility asking them if they take Medicaid, and they say, no, we take community waivers. And so you think they don't take Medicaid because they've told you something different, but they all basically mean the same thing. So there's a lot of terms out there. You also have to be aware of programs that might be able to help before you're ready to move into a facility. So there are definitely in-home services that can help. So maybe you just need somebody to come in a few times a week. Maybe we still have husband and wife together at home, and we just need somebody to come in and help out when the wife needs to go out and run errands and do grocery shopping. You can get somebody to just come in for a few hours like that. There are also day programs that are available for these individuals. So I don't like this term, but they call them adult daycares. So if you had to, you had to get somebody with care because they couldn't be left alone, and you're going to be gone every Friday because that's when you do your shopping and you volunteer or things like that. There are day programs where that individual could go just for the day, but they don't have to move out of the house permanently. There are also programs available through the county that can offer respite care. So if you've been caring for your husband for the last 2 years at home and you just need a break, or you want to go out of town for a couple days to visit family, and you don't know how you're going to be able to do that with your husband with diminished capacity, there are programs available through the county that will help with that. They can have someone come and stay in your home for a couple days. They can have you take your loved one to a memory care, not permanently, but just for a few days while you're out of home. So there are programs like that available through the county. Now, if you're to the point where, we're not just looking into it anymore, but we're ready, where we really do need to find a facility. We just can't care for our family member at home anymore. We have to start looking for a facility. What are we going to do? How are we going to look for them? So first of all, we need to determine what kind of facility we need. Again, assisted living, community-based residential facility, that's the CBRF, memory care, skilled nursing, all different levels of care. And you're probably not going to know what level you need. So someone at the facility might be able to help you with that. Doctor might be able to help you with that. The county might actually be able to do an evaluation and help you with that. And then there are also private professional organizations who can help with that. So figuring out where we need to go to get help. And then once we've looked at a facility, or we're ready to tour a facility, we want to make sure it's a good fit. Sometimes there are waiting lists. So you might find a place that you really like, but there's a 6-month waiting list before we can actually get our spouse in. Sometimes we find a place we like, but they don't take Medicaid. We're kind of wary of those places if there is a chance that we could run out of money. The worst thing that could happen is you're in a facility that doesn't take Medicaid, you're there for 3 or 4 years, and now the money has run out. At that point, they kick you out. You have to go find a new facility. So we really do look for facilities that will eventually take Medicaid. You want to know if, when you are able to get on Medicaid, are they going to make you switch to a smaller room or a shared room? So that's good to know ahead of time. And what's really nice is after you go on Medicaid, usually the facility will let you keep your room as long as you're willing to pay the difference out of pocket. So that's something to discuss ahead of time so you know what to expect. So once you've picked a facility, they're going to have you complete an application for that facility. They do ask for a lot of information. It's mostly with regard to family members, your emergency contact. They're going to ask a little bit about your medical situation. They might ask you to do a HIPAA release so they can get your medical records, make sure that they can take care of you in the facility. And then they're always going to ask for the financial information as well. They want to make sure that you can actually pay for staying there. Most facilities in the area want about 2 years of private pay before you go on to Medicaid. So when we're asking them, do you take Medicaid? They'll say yes, but after you've been here for 2 years. Some are 1 year, some are 3 years. So it's always a little bit different, but I'd say 2 years on average. So we want to make sure that we're giving them that financial information so that they understand and they know that you're going to be able to pay for the services. So you go ahead and apply, and then once you're ready to sign the contract, we do recommend that you have our office review that contract first. So it would either be myself or Mark who would review the contract for the facility. And what we're looking for in there is if they have any kind of unusual terms or conditions where they won't let us apply for Medicaid, they won't let us do Medicaid planning. Maybe they have some language in there about having the kids guarantee that they're going to pay if mom runs out of money. So those are the kind of things that we're looking out for, and we'll let you know if we find anything unusual in the contract. Now, this process can be very overwhelming, especially when you realize how many facilities there are in our area, just in Southeast Wisconsin. There's so many to choose from. You don't know which ones are good, which ones are bad, other than maybe you've heard from family or friends, and they change ownership every couple years. So even if somebody was there a few years ago and it was a great place, it might be under new ownership now and not such a great place. So it can be a very overwhelming process. So we recommend that you work with an organization to help you through this process. It's not something that our office would be able to help with. We can help with, telling you what to look for, and we can help with the financial side, but actually going and touring facilities and asking the right questions, you're gonna wanna work with somebody else to do that. I have a couple places listed up there, and they all work a little bit differently. So for example, you've maybe heard of A Place for Mom. It's an organization where when you contact them, they will try and help put you in contact with a facility that has openings that would be a good fit for mom. But they don't get real involved. And from what I understand is, you call them up and they maybe give you a list of 2 or 3 places that they'd like you to go and look at and tour on your own, and then you pick one. So that's kind of the bare minimum that they can do. The place that we work with most often is called Oasis Senior Advisors, and they are much more hands-on. They will actually make the appointments for you. They will go along with you to tour the facilities. They will actually ask the right questions for you. So not all of these professional organizations are created equally. And so, how much help you get depends on which one you go with. As far as how these professional organizations get paid, most of them will not charge you anything. They are instead paid by the facility. So if you tour 3 different facilities and you choose facility number 2 for your husband, that facility will pay a fee to this organization that helped place you with them. There are some of them that charge by the hour, but most of them it is free for you to use these services. And I will say, just before I forget, if anybody is kind of in this situation, could use some help at the moment, there are pamphlets for Oasis Senior Advisors on the table when you leave. So if this is relevant right now, don't forget to pick one of those up. So you found a facility, you had help finding the facility, and now what? So let's say, I've got an example up here. We've got mom who had to move into assisted living. Okay, so we went through the whole process. We updated her power of attorneys, her trust. We worked with Oasis and we found a really good fit for her. She sold her house and she moved into the assisted living, and the assisted living's costing her $5,800 a month. And when we toured the facility, they said, yes, we take Medicaid after 2 years have passed. Okay, so now we know that's our requirement. We have to pay for 2 years, and after 2 years, mom can go on Medicaid. So at this point, you want to get back in contact with our office because we want to make sure that when that 2 years is up, we can actually get mom on Medicaid. She has to qualify for Medicaid. So again, that's something that our office can help with. So I've got a little example of how this would work. So mom moves into assisted living costing $5,800 a month. She gets $2,200 a month in Social Security and pension. She's got $200,000 in the bank from selling her house and $100,000 in her IRA. So she's got $300,000 total, but she's $3,600 a month short for paying for her assisted living. So how can we make sure that we can protect some of her money, but also meet that 2-year requirement that the assisted living has? What we would do is we would take, of that $300,000, we can take about $214,000 and we gift it to the family. So it has to move out of mom's name in some way. It either goes into a bank account in her children's name, or maybe we set up an irrevocable trust. But that money has to move out of mom's name. And that is our reserve fund in case mom needs anything above and beyond what Medicaid covers. That's the reserve fund for mom for the rest of her life. And then after she passes away, that's the inheritance for the kids. And then we have to take the rest of her money, so that's about $86,000, and we're going to move that money into a Medicaid compliant annuity. So again, we're trying to qualify for Medicaid after the 2 years have passed. So what that annuity will do is it will pay mom $3,600 a month. That, combined with her Social Security and pension, is going to be enough to cover her assisted living bill each month. That annuity is going to pay her by direct depositing it into her checking every month for 2 years. After 2 years, all the money is gone, right? We moved $214,000 into the kid's name. The rest of it went into this annuity that paid her monthly. So all the money is gone after 2 years. She's met her 2-year private pay requirement, and she can now go on Medicaid. And that's how we do it.
Thank you.
And I think that's it for me.
All right, and so
All right.
yes, we're moving on to Brenda, who will tell us how to plan for our feathered and furry friends.
I have the fun of doing the fluffiest piece this afternoon, both figuratively and literally. The two in the center are mine. We've got 2 cats and 2 ferrets. And as a pet owner, I know that I need to make sure my pets are going to be cared for in the event that I can't. Sorry if there was difficulty there. And as an estate planner, I know what tools are available to me to make sure that that happens. So I work with older people whose pets are very near and dear to them and sometimes provide purpose for their lives. I work with younger people whose pets maybe have longevity, tortoises or parrots, or whose pets have very high care needs for vet bills, so horses, for example. I also work with people who just happen to own cats and dogs and want to make sure that their pets are cared for when they're not able to do that job. So there are three situations we need to talk through. The first is an emergency. The second is short-term incapacity. And the third is long-term incapacity and death. So let's talk through what options are available for all of these situations. For an emergency, my recommendation is that you write down pet sitter instructions. Similar to what you might leave for a babysitter, you want to name who the caretaker is going to be. And I always recommend you name an alternate as well. And then check in with these people from time to time. Make sure nothing's changed in their world. That means they would not be able to take care of your pets. Then you want to name the name, the age, and the medical history of each of your pets. You want to name a name and a contact information for a vet and an alternate vet. Not all vets take care of all pets. So for example, for our ferrets, I have to go to a vet that's further away than I do for our cats. So make sure that you have a vet listed for each pet that might need a specialty vet. Also name the name and contact information for family and friends in case something goes sideways for your caregiver. You want somebody there as a backup. And then name as much detail as you can for your pets. What are their favorite toys? What are their favorite snacks? What food do they eat? Are they under any medical care? The more detail you can add, the easier it's going to be for your caretaker to step in and take care of your pets. And then what do you do with it? You share it. You share it with your friends, with your family, with your neighbors, with your mailman, anybody you can get to take it, you give it to. And that way, if something happens to you, everybody knows what to expect. The second thing to do is to identify where your estate planning documents are located. So make sure that your agents and your trustees and your caretaker know, where are my estate planning documents? If they're in the library on the lower shelf, make sure everybody knows that. The documents don't do you any good if people can't find them when they need them. And third, use window stickers and wallet cards. So these came from the ASPCA, but HAWS, the Humane Animal Welfare Society of Waukesha County, will also give these out. You place these on your doors and your windows, and that way if an EMS crew or police or fire department need to stop by to take care of you, they know there's a pet in there, and they know who to contact about that pet. And then the wallet card, this is just something I printed up using the smallest font possible. It names my pets and my contact information and contact information for the caregivers of my pets. I tuck that into my wallet, and that way if I'm in a car accident, the police may find it and they'd say, hey, she's got some pets, let's contact these people. And so it's a way, again, of taking care of your pets if you're not able to. The next situation is short-term incapacity. So let's say that you're pregnant, or you're planning on going through chemotherapy treatment, or you're planning a surgery. You need some way to make sure that your pets are cared for during those few days or weeks when you're not able to do that. So one of the options is to pay for a professional pet sitter to come in, and they take care of all of your pet's needs. The other option is to consider family and friends. If you're thinking about having family and friends come over, think about what the different needs are for your pets. So for example, your pets need to be fed. If you have dogs, they need to be walked. If you have a cat, the litter pan needs to be cleaned. So if you break down the different needs, you can assign different people to each of those needs. Your niece is willing to come in before work and feed your pets. Your neighbor's willing to come over and walk your dogs a couple times a day. And your son's willing to come over and do litter pan control. So if you break it down, it makes it easier for everybody to step in to help care for your pets. I do recommend that you not have the person who's caring for you care for your pets. Their energy and time is going to be taken care of with you. They may not have much left over for your pets. So consider naming somebody other than the person who's taking care of you to make sure that your pets are protected. I keep putting this down, I should just keep it in my hand. And the third situation is long-term incapacity and death. The long-term incapacity means that you're moving to an assisted living program or a nursing home and your pets cannot come with you. Not everybody's going to face this in our world, but we are all going to face death. So we need to make sure that our estate planning documents reflect the kind of need we want our pets taken care of with. So make sure that your estate plan reflects your pet's needs. So there are different ways of doing this. One is an informal agreement. The other is to use a will with testamentary provisions in it. And the third is to use a trust. Now, informal agreements, this is what everybody does. They have an agreement with their friend or family member. If something happens to me, please come get my cat and take care of my cat. Sometimes money transfers with that, sometimes it doesn't. But it is simple and it's easy to do, which is why it's frequently used. If you do it in conjunction with pet sitter instructions, it can be quite effective as well, especially if you have a modest estate or if you have typical pets. Dogs and cats is frequently what we'll work with. If, though, you have a more complicated estate and your pets have more complicated care needs, then you might want something a little more permanent. And our options there are to use a will or to use a trust. So a will, get to that part. A will, you can write, unfortunately for us, we think of our pets as people, but pets are actually considered property. So you can transfer ownership of them using a will. Now, there's some downsides to doing that. One, a will is a death document. It does not help you out if you're incapacitated. It only kicks in after you've died. The second is that you have to walk that will through a probate process. So a court has to approve of these transfers. And that can take anywhere from 6 months to over a year. And during that time period, there is no legal ownership of your pet. The third is that it tends to be the most expensive way to administer an estate. So for these reasons, you might not want to consider using a will unless your estate is fairly simple. So what is our other alternative? The other option is to create, you're right, Mark, this is sensitive, to create a pet trust. Wisconsin law now allows us to do this. They're treating pets more like people. You can create a trust and have the pet be the beneficiary of that trust. And then the trustee or a court has oversight over it and can make changes if they need to. And it has to only be for pets that you own when you pass away. So you can name your pets, but then we always include language that says, or any pet I own when I pass away, to make sure everybody is included in it. Also, the funds can only be used for your pets. So you can't include friends or family members in this trust. It is only for your pets. So then you have the choice of where am I going to put this trust? Does this pet trust fall into my will, or do I put it inside of my revocable living trust? Many of you probably have a revocable living trust. We like using them because they're an incredibly flexible document to use. You can easily change it. You can easily amend it. You can do almost anything inside a trust that isn't illegal. So that's a good thing to be doing. So we tend to prefer putting pet trusts inside of revocable living trusts. Again, it deals with 3 different situations: while you're alive, if you become incapacitated, and when you pass away. And because it's going now while you're alive, there's very little time difference between the time that you become incapacitated and then again when you pass away. So it kicks in very easily and quickly. So if you're creating a pet trust, what do you need to consider while you're doing that? So this is the overview of what we need to do, and we'll go into each one in greater detail. So you're creating a pet trust. You need to think about 3 different roles. The first is who's going to be in control of the money? That's your trustee. They're managing the funds on behalf of your trust. The second is who's going to be the caretaker for my trust or for my pets? These are the folks who are going to essentially own and take care of your pets. And the third is what pets am I talking about? And again, most people say any pet that I own when I pass away. And pet trusts can be put in place for more than one pet. You also need to figure out how much money am I going to transfer to this trust? And a court can say, nope, that's too much. So you need to think about what sort of pet am I taking care of and what sort of needs does that pet have? So for example, I worked with clients this past year who had dogs, a parrot, and a horse. And they came up with a number that I nearly choked on when they told me how much they wanted to transfer. But then when we sat down and talked about it, I thought, no, that is a reasonable amount. Their dogs needed a great deal of medical care. Their parrot was young and was probably going to live another 80 years. And their horses are expensive. No matter what kind of horse you have, they're expensive. So you need to make sure that the amount you're putting into your trust makes sense for the pets that you own. There's a world of difference between taking care of a hamster and taking care of a horse. You also want to talk about what sort of standard of living do I want my pets to have? Can my dog go to a groomer once a week, or can I toss him in the bathtub once a month? Those decisions will make a difference in how much money you can place into your trust. Then we need to figure out, how do we get money out of your trust? You've decided how much to put into it, but how is your caretaker going to receive those funds? There are a couple different options. One is a monthly stipend. So a certain day of every month, money comes out of your trust and is transferred to your caretaker. So this could be a windfall for your caretaker if they're not spending that much, or it could be harmful if they're spending more than that amount. The other option is that they can submit receipts to your trustee, and your trustee pays those receipts. I like working with a combination of it so that my caretaker knows that my daily, day-to-day needs of my pets are going to be taken care of. But if there's an emergency, those needs will also be covered. I also like to encourage people to give them a thank you gift once in a while. So maybe at the end of every year that your caretaker is taking care of your pets, they get a monetary Christmas gift or an end of year bonus. It's just a nice way of saying thank you so much for taking my pets in and for loving them. Then you want to talk about what's going to happen at the end of my pet's life. Do I want some sort of humane euthanasia if they hit a certain level? And what happens to their bodies once they pass away? Do I want them cremated or buried? There are a lot of funeral homes now that are offering pet cremation, and every vet out there is going to know somebody else who could do it for you. So maybe you want those ashes spread in a place that has meaning for you and your pets. You can name that inside of your pet trust. And then if your pet passes away and there's still money in the trust, where do you want that money to go? You can name family, friends, a pet organization such as Haws. You get to have control over what happens even that far in advance. And then are there any additional considerations you want to take into account? So for example, for these folks who had a parrot and a horse, we named a group of people who they could go to, the caretakers could go to if they had questions. So for the horse, we named a vet, a farrier, a friend who understands horses, and the trustee. And that way, if something happened to the horse, the caretaker has a place they can go to ask questions. Would it be reasonable if I did this or that? So it helps that caretaker out if they're facing a period of concern for your pets. So there are three situations that we talk through: an emergency, a period of short-term incapacity, and long-term incapacity and death. So here's my call to action. If you own pets, please create pet sitter instructions. Write them out, write them on your computer. However you get them written down is great. Share them with everybody that you know and tuck them into your estate plan. And then if you feel that your pets have greater needs than that can manage, give us a call and we'll gladly look through your estate planning documents and see where we can put places in to help your pets. So please keep in mind, you love your pets, they need you, and they can't speak for themselves. So please take the time and speak for them.
All right, so this is the final part of the program. Roman and I, who do the post-death trust administrations in our office, will do the presentation. So there are two things we always start this program off with, and that is, why do I have a trust in the first place? And so it helps with incapacity planning. It's probably the best type of tool that you can use. You can name a successor trustee to step in when you are unable to do it yourself. You can leave instructions on your own long-term care and also for the care of those in your family in a way that you really can't in any other type of document. So what about death? Well, I think most of you know that a trust is going to avoid probate. It reduces the cost of distributing the property. It's much less expensive than a probate. You're going to reduce or eliminate estate taxes if you're a married couple. It can provide lawsuit and asset protection to your beneficiaries for their inheritance. And then we can pass assets to your loved ones using a trust with real certainty. A lot of us are concerned about a son-in-law or a daughter-in-law. We're fine with our son or daughter getting the money, but we don't want the money to slip away, and we'd prefer it to go to the grandkids. And so a trust helps make sure that your plan stays on track to get those things done. And then it allows the creation of lifetime trusts with asset protection for your own kids. Now, before we move on to, Roman is going to start talking about what a successor trustee needs to do. But I'd like to see the hands of the people in this room who brought a son or daughter along, who's a likely successor trustee. And we see, and those successor trustees, keep your hands up. How many of you know where the red book is? Almost everybody. Awesome. Here, this is it. We have, for years, this is the color we've been using. I'm glad we've never changed the color, because we can always say, let's go, do you know where your red book is? Almost everybody does, and then all the things that we want to talk about are in the book. So, but in years past, we have had more of a failing grade for our audience. Today, I thought you guys did great. So now I'd like to introduce my friend, Roman, who is going to help us understand what trustees are supposed to do.
And thank you all for coming this afternoon. This portion, we talk about what successor trustees are going to need to do, but it's real important to stress that our law firm, primarily these days, Mark and I, are here to help these successor trustees. And oftentimes, in every case where a successor trustee needs to take over, or they think they may need to take over, they're always welcome to get an initial consultation with us to find out what their duties are. So when the person who set up the trust, either it may be in a first spouse for a married couple, or a single individual dies, then the successor trustee has certain responsibilities that are spelled out in the trust. And it's many pages of lists of things that the successor trustee may need to do. And I'm just going to go over here what some of the highlights are. And then again, I want to stress that these tasks sound like they could be fairly complicated, require record keeping. But again, oftentimes all our successor trustees are doing are coming to meetings at our office. Also, we do many on Zoom now, or we do conference calls. We actually learned in this process that since COVID started, that many times when we had face-to-face meetings, that it was a time drain on the successor trustee, either having to go back and forth to our office. So we've been able to accommodate many of these tasks and many of these meetings without actually having to have an in-person meeting. You're always welcome as a successor trustee to have an in-person meeting, but we've learned that some of these can be avoided if that's more convenient. Many times the successor trustees have other obligations and they want to fulfill their trustee duties, but also not neglect their other duties in life. So these are some of the tasks that are going to need to be done. We're going to need to put together a list, we call it an inventory, of what the assets were as of the date of the person's death. And this is important not only to know what we're going to have to put in claims for, but also to establish the value. Mark referred to step up in basis, which is a calculation that helps when an asset is sold after someone's death. So we want to have a good legal document that will show what the value of the capital assets were on the person's date of death. Then we're going to help with claims. And claims can go both ways. A claim for an asset that the decedent had, it might be an annuity, a life insurance policy, a retirement asset. Those forms are sometimes pretty long and not the easiest, not the most user-friendly to fill out. So we would help fill those out. The successor trustee actually signs those forms, but most of the time we prepare them and help with the strategy as to how claims are made. the timing of claims can impact the tax situation. So we want to make sure that those factors are taken into consideration. And then there are going to be some expenses. There's going to be the expenses of maybe a CPA that needs to help with the tax returns, our attorney's fees, and then also in many cases the trustee will want to take a fee, is entitled to a fee. The times where a trustee may not take a fee is if they're the sole beneficiary. Because if you're the sole beneficiary of a trust and you take a trustee fee, you're turning something that is non-taxable income into taxable income. So that's something that we help people understand. Even though you're entitled to a trustee fee, it may not be necessary for you to take one because you're going to get the proceeds of the trust in the end anyway. Next slide.
There it is.
Okay, thank you, Mark. So the trustee then is going to have some additional tasks of making sure the taxpayers, the final taxpayer's individual tax return, 1040 return, is done for the year of death. And this is something that in our initial meeting, Mark and I will spell out the time period for that final individual tax return, and it will be January 1st up through the date of death. So that'll be the final 1040, and if it's a married individual, it'll just be indicated on that return that one of the normal joint taxpayers has passed away. The other return that needs to be done is a 1041 return. And that return, we can, in the case of many married couples, when they pass away, oftentimes we do not need to do that 1041 return. But in the case of the second spouse to die or an individual who dies, we want to make sure that that 1041 return is done. It's called a fiduciary tax return. The trustee signs it, and normally our firm will prepare that return as part of the trust administration tasks that we work with the successor trustee on. There may be additional tax returns that need to be done in more complex estates. We might have to do an estate tax return for larger estates. We may have to do an estate tax to take care of something called portability. We've talked about that at previous programs, and that's where a surviving spouse can use a portion of the deceased spouse exemption. Mark talked about the exemptions in the earlier part of the program, and there is a way also to transfer that exemption, and that's done with a specific tax return known as a 706 return. And then at the end of the process, we assist with the distribution of the estate to the beneficiaries. That may be an outright distribution where the money is just transferred to the individuals, or it could be a transfer to a trust that's set up for the beneficiaries. We would want to make sure that before all the funds were distributed, that we looked ahead to see if there were any hidden costs that may come up in the future. So Mark and I would oftentimes recommend a reserve in order to make sure that if something comes up down the road, that the trustee doesn't have to have that very, very uncomfortable discussion with the beneficiary saying, hey, I need some money back because there was an expense that we didn't know about. So we want to make sure when we go through that process of determining claims that we look ahead, and also that may be future tax liabilities that we want to take care of. And then finally, we have in recent years, and this is sometimes due to the fact, unfortunately, we love to see you to come in for reviews of your plans. but we have had situations where plans got outdated, changes in the law made them contain provisions that really weren't necessary any longer. And fortunately, under the Wisconsin Trust Code that was adopted a few years back, there was something that we could always do, use a trust protector amendment, but it even became more popular in recent years. And Mark's going to explain many of the things we've been able to do with the trust protector powers that have helped out a great deal in many of our trust administrations.
So the trust protector is, as Roman said, it's a commonly used tool for us if it's in place. And we talked about this on last year's Zoom program, but we're going to go into it a slightly different way today. So who is the trust protector? If you have that in your estate plan already, it probably doesn't name anybody. It will say that the attorney for the current trustee is the person who can appoint a trust protector. And as long as that person's independent of the family, the lawyer can appoint him or herself, and that's often what we do in our law firm. We're the ones that see the issue of why we want to use a trust protector, so we'll recommend that to you, and then we'll often appoint ourselves. So this is a person that can modify the trust, right? When you die, your trust becomes irrevocable. And so the only way to change it in all the states, including Wisconsin, ordinarily, is you must go to court, file a petition to modify or reform the trust, say, Judge, here are the things that we want to see changed or updated, and you may or may not get your wish, depending on what the judge thinks. So this is a way to do that very same thing outside the court system. You'll have much more certainty that it will get done, and as long as the modification is consistent with your needs. And it says that when we have installed a trust protector in that language in your trust, it says this person can only make modifications consistent with what I was thinking I wanted to see happen. So there's two ways to have a trust protector. It's either already written into your plan, and I think anything that we've written since probably 2006, 2007 has that in there. But sadly, we see people who pass away and they come in and their trust was from 1999. And there's no trust protector in there. But there is a way to appoint one. The terminology isn't helpful. It's a non-judicial settlement agreement, in English, a settlement agreement that's outside the court system. And as long as everybody who is what's called an interested party signs off on it, it's usually just your closest relatives, you can then get a trust protector appointed, and then that trust protector can make modifications that may be helpful to you. So those are the two ways to do it. The ideal way is to have the language already in your estate plan. So one of the things that we want to fix a lot of times is people come in and their tax planning, their estate tax avoidance planning is inappropriate. And here's the most common thing that we see. You have an estate plan, you're married, and everything would go to your family trust or your survivor's trust inside your plan, but you must put the decedent's property in the family trust. We call that a mandatory funded family trust. We set up dozens and dozens of them because we did it when the estate tax exemption was very low, like $600,000 or $1 million, and you were either there or over, and we wanted to make sure that money went into the family trust to protect it from unnecessary estate tax. Well, what's saving you from the unnecessary estate tax now? The size of the exemption. The exemption's so big, it's $12 million. Don't raise your hand if you have $12 million bucks. But I'd be lucky to see one or two hands go up, honestly. It's way less than 1% of the population of the United States that has an estate that's subject to estate tax. So if you're sitting on one of these family trusts, what has to be done is we either have to fund that family trust and spend all kinds of money on Roman and I to get it done when you're not likely to need it or benefit from it. Why would we do that? And so Roman and I wanted today, in spite of the fact we're talking about doing what's right in front of us, we want to urge you, take a look at your flow chart. And if you've got one of those big old family trusts sitting in there, you might want to call us and see if you need to update your plan. But we have developed techniques to help solve that problem using the trust protector. If the trust protector language is already in there, it'll say you can make adjustments due to changes in tax law. And there are lots of tax laws that we see. It's the estate tax, capital gain tax. So if we can avoid that, we're going to do that. It used to be our choice was either we had to pay the estate tax or the capital gain tax, but we couldn't avoid both. And now we can avoid both. And so we want to do that for you if we can. And the trust protector is going to help us with that. So we mentioned that we want to get a step up in basis for your kids, for their trusts. What else do we see that we might want to do with a trust protector? Well, we want to make sure the inheritance is protected from lawsuits and claims. We want to make sure your kid's inheritance is protected from Medicaid spend down requirements, so that when they get to be older and they start running out of money, except for in their trust, they can preserve and protect the trust because we've made the correct modifications to the trust. We can typically adjust who is serving as trustee. A lot of times our clients will come in and one or more of the kids has passed away also, and they were named as trustee. How do you fill those vacancies? Well, a trust protector could do that. And so we find out from the family, who would you be interested in? But I can tell you one of the most common things that we've done is the trust code in 2014 started permitting us to leave inherited money in trust to our children. And that child does not have to have a co-trustee to get the protection from lawsuits, claims, the red light, hitting the van full of trial lawyers. That protection can be there even if your child is serving as the sole or only trustee. And most of the time we talked you into naming a co-trustee for your kids. And then a lot of times you'll have told us, God, we wish our son or daughter didn't have to call his brother to get money. And now we fix that post-death using the trust protector, as long as we know that you, the parent, wouldn't have objected to that. That would have been something that you would have, if you'd known about it, you would have said yes to it. So those are the things that we're doing typically with the trust protector. Now we're going to have Roman tell us about the fiduciary duties of a trustee.
So Mark, get your hand on that clicker because we're going to move fast through
Yes,
this.
sir. Yes, sir.
All of our successor trustees are very honest people. We don't need to preach to them, but I do want to just state a few things. Act in good faith. When you do have control over the trust assets, we just want to make sure we're aware of what's going on with the market, how those assets are invested. Sometimes it makes sense if they were in something that was highly volatile to move them out of the market. And those are things that we can talk about. And we also encourage you to talk with your financial advisors or the financial advisors that the people that set up the trust had, and work with them if there needs to be a change in investments. The successor trustee has the instructions in the trust agreement as to what they're supposed to do and what steps they're going to take. And the most important thing to remember here is that you owe, as a trustee, a duty to all of the beneficiaries of the trust, so that in dealing with the assets, you just want to make sure that you treat everyone fairly. So if there's a beautiful cottage on an acre up in Minocqua, you don't sell it to yourself for $1. It just would not go over well with the other beneficiaries. You have to make sure that if you can deal with assets that you would receive, but you just have to make sure they're dealt with on a fair basis. And because it's not technically your money until, if you're a beneficiary, that portion is transferred to you, we want to just make sure that everything is accounted for well, so that down the road, if maybe there's a sibling that's has a grudge against you since grade school that we don't want to give them a big target to shoot at to say that you were unfair to them. So that's really what we want you to do, is to treat everyone fairly, and certainly if there's any questions about how assets should be transferred, please just remember we're there to help.
So those of you who have been named as somebody's successor trustee, do you get paid? You absolutely do. And it can be, it'll say in the document a reasonable fee, and that can be by the hour. It can be a percentage of the gross estate if you're wrapping up somebody's estate. But you have to remember, as Roman said, your fee is reportable as income tax. So for example, a spouse, where the first spouse has died, isn't going to take a trustee's fee because he or she gets all the money anyway. Why not take it tax-free instead of subject to income tax? And you don't have to take a fee if you don't want to. And we see this often with families with 2 or 3 children. The one child that's named as trustee will say, I don't need to take a fee. It doesn't help get a target off your back, but psychologically it does. Because if your family thinks you're getting paid, they're going to be a little more picky about how things turned out. So do you have to do this by yourself? We hope we've gotten across to you. We've got quite a team. There's Roman and I, and then Camise Figures and Tammy Rundle. We all work on these cases together, along with Amanda McCormack on the tax side. And so we're not there just to help. We're there to get it all done for you. Your job is we try to help you understand what you're doing, and here's some paperwork to sign, and we try to move you through the process so that the estate gets distributed in an efficient manner. So no, you don't have to do it by yourself, and plus there's the rest of the team. There's a financial advisor, there might be a CPA, insurance professionals, all can help out. If you are getting long-term care, you may have a care manager. So all the reasonable costs of these other professionals is payable out of the estate. So that's the scoop on trust administration. And now we're ready to wrap up. So we want to tell you what our services are, find out if you need a review, talk about how to ask for an appointment if you need one, and off we go. So this is a hard slide to follow. The services are, the first column all the way to the left is estate planning services, and you know what those services are: trusts, wills, powers of attorney. We help draft and get those things done and help fund trusts. Elder law, that's helping individuals become eligible for Medicaid assistance for their costs. And Stacy didn't mention it today, but she also does irrevocable trusts that where we're looking forward. We know we're going to make it 5 years. We can transfer assets out of our Medicaid estate so that they're protected from Medicaid spend down. Then we've just been talking about the trust administration services, and the tax planning is all baked into all the things that we do. We're always paying attention to making sure that we minimize however much tax you pay at any stage of what's going on. So what kind of a review would you like? It used to be that they were all in person. But again, COVID taught us how to use the technology of Zoom and how adequate, actually, many times a phone call is. Then you don't have to get in a car and drive, find parking, and we can usually get things done. Often the signing meetings we need to have in person, but the planning meetings can be, if you said give us a Zoom, we're not going to fight you. We're going to say we'll set it up and we'll run a Zoom conference. So if you want to meet in person, there are locations. We still have our downtown Milwaukee office. We moved about a year ago, a little more than a year ago actually, to 759 North Milwaukee Street. We have still got the same Waukesha office and the same Cedarburg office. And Roman and I are, and I think all of us are willing to come to your home if it's a medical issue where it makes it difficult for you to get out and about. So how do you ask for an appointment? Look at that phone. I know we've run over a little bit, but I always think about, I watched Ellen DeGeneres one day, and they had a young lady on there who was 22 years old, and they put out a big yellow pages, the phone book, and a phone. And they said, here's what you need to do, order a pizza. And she had no idea how to use these tools, none. It couldn't dial the phone, couldn't find, didn't know that it was organized by things inside the yellow pages. It was pretty funny. Anyway, but you can use yours and give us a call. Anybody who answers the phone is going to be able to, you don't have to reach Roman, you don't have to reach Stacy or Brenda. You can reach one of our people that answer the phone. That would be Patty and Annette, and they'll get you on the calendar and make sure that if you're coming to the office, you know how to find your way there. Or you can email. We're all modern that way. And we do want to hear from you. Today, because we have a live program for the first time in 2 years, we've got these little postcards that are at your places. And if you want to come visit or get a call from us, just put your name down and let us know, and we'll get you on the calendar. And a lot of times this program will generate a couple of months worth of appointments for us. So please be patient with us. If you do have urgent needs, say so. And we will move heaven and earth to get you in.